So, hey, I'll present to you Oracle versus Google, and just for further references, it is about platforms' right to interface on chains such as the blockchain. So you might stumble over the doctrinal aspects of this case quite a lot. And to begin with, I also want to highlight the theoretical importance of the differentiation between open libraries and closed archives. And I don't know if you ever heard about the Manifesto Mein Kampf. It eventually entered the poison cabinets or Giftschränke and was gathered there side by side with banned books that were deemed to burn during the Second Reich. It survived the Allies' attempt to ban Mein Kampf from circulating on European markets, and ultimately Bavaria's regional government kept it under closure in National Libraries archives, and they held the copyrights until they ultimately expired in 2016. And now the Munich's Institute of Contemporary History is about to publish a new edition of the book. Coming now to the chronology of the case, in 1992, Sun applied for a 104 patent, and shortly afterwards, Java developed a platform for computer programmers, and Google saw the potential of this platform and acquired Android in order to release software development kits who were perfectly interoperable with Java. So after the copyright registration got issued in 2004, Google entered into negotiations with Sun for a license to incorporate Java's libraries to their own operating system. But these negotiations fell through, so Google just decided to implement the infrastructure that surrounded Java in order to avoid paying for license fees. And Oracle then acquired Sun and filed a lawsuit against Google. So in 2012, the Northern District Court found that the API is not copyrightable. And 2014, the Federal Circuit reversed this decision. In 2015, the court ruled in favor of Google. In 2017, the Federal Circuit held that the jury's fair use finding was erroneous, and this is a hint with respect to the de novo judicial review. So looking now at the 2019 decision, we can clearly tell that the jury found a copyright infringement of 37 Java packages, and they also deadlocked the fair use defense. Then this year, the court filed in a 6-2 decision that Google's use of the Java API fell within the 4-factor requirements of fair use. And in analyzing the payoff metrics and the long-lasting quarrel of this dispute, we can just say that here in the first quarter, both parties found themselves in a quasi perfect Nash equilibrium. So Google's payoff is greater if they continue, whereas Oracle's payoff is proportionally greater if they continued as well, because they seek compensation for 8.8 billion in damages, and further the exclusive right to take advantage of their own innovation. Assuming that we had then just stability, and this is called a Merton's stable equilibrium in the very beginning, the Pareto frontier could only shift if Google formed a collision-proof Nash equilibrium, and that's when you bring a third party to the negotiation table, and this party has something that might disproportionately affect the outcome of the jury trial. And in this case, the amicus curiae could have played such a role. So it wasn't that foreseeable that the dispute would play out that way after 2019. So we now want to look at where the cursor currently stands in this dispute, or stood. The ensemble of virtual libraries are called machines or virtual machines. So general public licenses do contain class path exemptions. These class path exemptions are declaring codes which allow for interoperability or functionality for developers to interface with virtual machines internal folders. So only through class path exemptions they can get a very concrete description on which folder they want to open. And this description is then called the Technological Compatibility Kit, or TCK, and it usually runs on a commercial license. And this is because there's a difference between obtaining the right to store your book in let's say public library and entering the public library to revise a specific chapter or educate yourself on a subject matter. The public library itself is in this case represented by the Open Java Development Kit, or Open GDK, for the given reason Google felt like it was absolutely necessary to access Open GDK Java sources, and they wanted to further open up the archives of the TCKs in order to allow third parties to use the class path exceptions on their own terms. So consequently, this fork would have splitted the class path exceptions from the protected area of Sun's control over its own exclusive rights. So in reaction, Google created a clean room version of the Java libraries, and the clean room version contained all the class and method names. So this is problematic because clean rooms are designed to rely on independent creations. And if we now take a look at the range check function, we can tell from looking by this declaring lines of code that method and classes were the very same. So there's nothing novel about the Android version. So going now into the rationale of the judgment, we have two fundamental questions. Under which conditions is a software company entitled to copyright protection for its programming platforms at all? And can the secondary right of that programming platform infringe fair use copyright protection? And pursuant to Chapter 17 of the Copyright Act, computer programs are sets of statements or instructions, whereas copies are any known method from which work can be reproduced. So our declaring code is essentially an indicative method or of operation or API. And in the given case, the Java Lang mask list set the necessary switches for developers to interoperate or interface on the platform. And in the Lotus versus Bolin case, it was held that a popular spreadsheet program contained a very specific menu structure that was protected by copyright infringement, and indifference implementing codes are operating the command formulated in the declaring code. So Oracle's argument here is there's more than one way to write a declaring code, and developers can use a language that permits them to create the API interface on themselves. And C is, for instance, interoperable with Java, Swift, the Apple language for iOS systems. It's interoperable with Java. And Google could just have recreated Java in another language, but used its functionality in the more or less very same way. So Oracle's argument here is every word in English has a specific meaning, and some are de rigueur meant to convey ideas. And one could say, hey, that's an unfair safeguard mechanism, but maybe there's a reason that does not cover up for taking out the technological core. And let me explain this a little further. The benchmark here was set in Baker versus Selden, 1880. The judges applied the merger doctrine to the case, which says that only the way another expresses the idea or the fact is protected. So essentially, the idea expression dichotomy strikes definitional balance between the First Amendment and the Copyright Act by permitting free communication of facts. And in this case, the Supreme Court therefore held that a copyright in a book about an improved system of bookkeeping did not entitle the author to prevent others from using the ledger system described in the book if it did not rely on a very expressive and innovative idea. So it is about the art described in the ledger system of the book. And if there's nothing novel about it, it's just not covered by copyright. So I'll illustrate this a little further. So imagine you are a baker and you want to sell cookies. You would use what everyone would use at first glance: flour, sugar, and chocolate chips. You're following the basic commons playbook. And that's essentially what Google's claim here is. These are just ordinary sweets. And now we'll just say, okay, no one ever thought about adding salt. And you are a very creative baker and decide to add a significant catch of salt to your cookies. And you do it because you know it will enhance sugar addiction and it will spark the consumer's appetite. It might seem obvious, but nobody thought about this before, as I've already mentioned. So now the other bakers know about it, and they are lurking in the background and want to sell this addictive cookies as well. And their only option is to sell these cookies and bring them on the market by downgrading the idea and claiming that it's just too simple to extend to their area of expertise as well. So they say, hey, I can make cookies without salt. But adding salt does generally extend to my commons playbook knowledge kit right from the beginning as well. So this became initially about how we shall protect the craft of the craftsman, and Coca-Cola has a patent on their 100% inartificial no-sugar stevia sweetener as well. I will end this copyright case by the very expressive and copy-worthy quote of John Lennon: "Art is only one way to express pain." You can, meanwhile, take a look at the GDK's string compared to of Oracle and Android, and just admire the fact that there are multiple ways to write any declaring code, right? So we will now technically analyze the absence of a common creative license and Google's fair use defense strategy. So under Section 107 of the copyright law, we have limitations on exclusive rights, which shall, with respect to fair use claims, well, entail the purpose and character of the use and include whether they are of commercial nature or for non-educational purposes. And if we now look at the first requirement, we might ask ourselves, okay, what happened here? We have 3% of commercially used declaring codes, and the rest is completely free. And if there is well, a legitimate claim to grant access to a variety of different people, we might ask ourselves what we do have licenses for. I mean, licenses are proportionate to revenue. So even if you're a small player, you won't be able to access the market just because there's a license in your way. And the second requirement is the nature of the copyrighted work. So Google's defense here is it enables interaction between programs. This is true. And the amount of the use upon the potential market for a value of the copyrighted work. So yes, only small quantities got extracted, which does also mean that there was a 97% big area of unexclusive possibilities for Google to use Java. And the effect of the use upon the potential market for value was also mentioned in the last step. And Google's defense here is there's no market harm, and this is a question of perception. I mean, codes have been made available, and the open GDK licenses do differ from the TCKs. So we do have here a slight problem, because it is really about from which perspective you are portraying the problem. And ultimately, we do have a fundamental problem. What is the raison d'etre of commercial licenses at all if it ultimately comes down to if anyone else has a commercial interest in your innovation, we will just apply this fair use requirements and strip you of your exclusive rights. And maybe there's a sine argument that could have been made, such as in the Alexander versus Haley case. So some ideas can only be expressed by certain elements, which is true. And the expressions are under these circumstances unprotected, thus unlimited to verbatim copyrights. I would just hint here quickly to the clean room example. So other companies proved that there are other ways. So this is a one-handed argument, and the Supreme Court denied therefore patent claims right from the beginning. And I would just like to us to take a brief look into the three requirements. So we have utility, it's reproducible, and then novelty, it's unknown before application. And then we have inventiveness, which means that it's not obvious to a skilled person. And in October 1967, Christopher Latham Soule submitted a patent application for an improved writing machine. And this manual typewriter was one of the most complicated pieces of mechanical machinery that translated query language at that time. And essentially, the patent that got submitted for this type of query language just opposes the notion of Google's argument. Query language in itself is too simple to be subject to patent law provisions. And especially the utility requirement is quite controversial because in the given case, the court somehow ruled like if you poke that coded recipe book for salty cookies with a yardstick, it won't still do anything useful for you. So the main argument of the court here was the industrial impact or sky will fall argument. So if we go now into the declaring code, we can see that one firstly has to invoke the package function, which is containing the 37 API packages, and then the class function, which does contain the GNU folders and the 60,000 different method headers, and one of the very useful ones was the Java lang math max AB function because it just allowed in the last indication for a wide variety of over 6,000 different method headers. And then if we look into the library, so the last piece that has to be invoked, we can see that it already contained all of these different declaring codes. And just having this very clear cut is quite useful for Android technical devices and the recognizability of functions written in Java. So the inflammatory potential of the case is manifestly revealed by the 70 amicus curiae referrals or supporting briefs of rival tech companies such as IBM, Microsoft, and notably Mozilla to the court of last resort. So license fees are generally incredibly low. So the argument that it hinders companies to accelerate economic growth is just inaccurate. And the fees increase proportionate to commercial use of the technology. And as Amazon, for instance, got licenses for its software as service APIs, we could just argue, look, so many small businesses are operating on Amazon under this SaaS. So why should this not be possible for any developers who want to launch an Android app, for instance? And currently around 6 million developers have Java programming expertise. And yes, learning a new language can challenge the industry, but Android could cover up for this license fees as well or split it with developers. And additionally, Java has a 52% programming language market share at the moment. The monopoly threshold requirements are around 60%, I guess. And therefore, threshold requirements are not really met. But I mean, Google has a monopoly on quite a few markets as well, and nobody is really questioning why this big player needs to get its feet into the door of this market by turning the lock with the wrong key. And the Supreme Court might have given its quite a few new incentives to developers to add uniqueness to codes. And this special catch of hyper complicated uniqueness might make codes less interoperable. So this can create chilling effects on the industry as well. And ultimately, Rule 50 of the Federal Rule of Civil Procedures qualifies judgments as a matter of law if a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis. And Google's argument here is that the matter of law is the misunderstanding of the fair use standards. And according to the Seventh Amendment, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise examined in any court of the United States. So essentially, juries are not supposed to say, I disagree with what the jury says, and you should find yourself a different court instead. And then in 2018, the Federal Circuit's decision on the standard of review is referenced as being a de novo review. This means that the review is non-differential. They don't place any weight on previous court findings, such as in the lower court review of conclusions of law in Chevron versus Naranjo. And the new decision makers are now standing de novo in the shoes of the original decision makers, whilst having to consider all the material evidence put forward.